There's been a statement from Cabinet in which it says the Road Accident Fund has made progress in dealing with the settlement of claims and is now settling claims within 6 months, and that it has reduced its legal costs by 75%. In other words, that has made progress in its turnaround plan. But last week, the High Court in Gauteng ruled that the Road Accident Fund was wrong to change the accounting standard it uses. The fund had said it was changing accounting standards because it's a social benefit fund and not an insurer. The Accounting Board of South Africa says it cannot change its accounting standard. The High Court has ruled in favour of the Accounting Board. Also, the Constitutional Court has ruled in another case that the Road Accident Fund must pay the medical aid company Discovery because Discovery has been paying for the treatment of its members when they're in car accidents. The Road Accident Fund has refused to refund Discovery. The CEO of the Road Accident Fund is Collins Letsoalo. He's with us now. Collins, good afternoon. Thanks very much indeed for coming in.
Afternoon, Stephen. Afternoon to the viewers.
All right, it's a big job. There are lots of different issues going on with the Road Accident Fund at the moment. What progress are you making in the turnaround?
Well, we have reduced the legal costs 75%. As you know, we are settling claims much more sooner. But we also have reduced what we call the RNYP, which is short-term debt, from about 19 billion to about 9 billion this year. So I think we have done so well in the last 4 years. So we are continuing with the strategy.
You've also reduced the liabilities of the fund. How were you able to do that? What did you change?
Well, it's just a simple process of efficiencies. We're taking away from what lawyers used to take, and we're now giving it back to the claimant, as it were. So that's a simple strategy that says reduce your administrative costs and take whatever you are saving that side to the beneficiary, who is the actual ultimate beneficiary of this scheme, not the lawyers.
There have been plenty of cases of lawyers who've been benefiting far more than the victims have. Lawyers aren't always very popular. So you're basically saying that by removing the lawyers from this, you've been able to improve efficiencies and make the situation better.
Absolutely. That's what we've been doing. I think when we arrived, about 27 billion was going to the claimants. We have now increased it to about 39 billion. So we have, in the last 4 years, increased by about 12 billion a year.
Okay. There are arguments against you as well.
Of course.
And one of them is that basically the way you did this is that you made it too hard for victims of accidents to actually get their money.
There is no truth to that. The reality is this. When you come to the Road Accident Fund, you must ask for, you must give us information about what has happened to you for us to be able to settle that claim within 120 days. In 60 days, we must actually assess that. If we don't, it is, in terms of Section 24(5), a claim in all respects in law. Some crazy thing about this act, but the reality is that we're implementing it the way that it is. So we have continued to do that, and everything we do is in line with the law. So you can't come to us and ask for a compensation when you have not given us all the minimum requirements that we require for us to be able to assess whether you're entitled to that money or not.
Okay, I mean, obviously you would have to prove you've been in an accident. I fully accept that.
Absolutely, but Stephen, I must tell you that there are people that come there without even an accident report and want us to actually process that claim. And that's the fight that we are having. Yeah. And those are the fights that are taking us mostly to court.
No, sure. I mean, there have been plenty of cases where people have tried to defraud you. I accept that. The problem is that the High Court in Gauteng has ruled, in fact, twice that you've been making the process too difficult. And they told you to go back to the previous process that you used. In other words, a judge in Gauteng, I think they're separate judgments, have basically said that you were trying to make it too difficult for people who had legitimately been in accidents to get their money.
There's no truth to that. That's why we're appealing it.
So you're appealing both those?
We are appealing those court rulings because we believe that they've misapplied themselves, and then once the facts come in front of an appeal, we think we'll come to a different conclusion.
I mean, you're saying that a judge got the facts wrong?
Of course, they've got the court. The last one says that we are not a social benefit scheme. If you go to the...
That's a different case. I'm talking about the cases, the two Gauteng High Court judgments about...
All of them, the RAF Form 1. The RAF Form 1 says that we are not supposed to put in... If you go in terms of Section 7, Regulation 7.1 of the Road Accident Fund Regulation, it says that we will put a RAF Form 1 that we will change from time to time. That has not been set aside, but people say we can't do it. That we did it in terms of that law. So they need to set it aside, and our view is that it has been there since 2008. Why are people seeing the constitutional law of it now when we start to apply it? It's very strange. That's why we are saying that we are going to appeal this.
Okay, and you're confident of winning?
Absolutely.
Okay. The other case is about repaying medical aid. So in the past, what happened, if I've understood it correctly, is that when someone was in an accident, the medical aid would pay for their treatment. They would then come to you and say, this person was in the accident. We paid for this person's treatment. Will you please reimburse us? And for many years, that's what the Road Accident Fund did. You then changed the policy and said, we're not going to reimburse medical aids. Discovery went to court. In the end, the Constitutional Court, as I understand it, ruled in Discovery's favour and said, you must reimburse medical aids. And yet still you're refusing to reimburse medical aids.
Let's start here. They've never come to us. They can never come to us. The law does not allow them to. Let me tell you what they were doing. In a very unethical way, Stephen would be a member of a Discovery medical scheme, and what they would do, they would actually pay for what is called prescribed minimum benefits, or what is called emergency medical conditions, which by law they must pay.
Yeah.
Then they go and hire a lawyer. They say to Stephen, go and claim from the Road Accident Fund, and once you get that money, pay it back to us. They never came straight to us, because they don't have those rights to be able to do that. There's no constitutional court that found in their favor. It never said to us that we must pay them. It said it does not have jurisdiction. That's all it did. Now we have gone back to the North Gauteng High Court. The matter is going to sit in the front of a full bench because we had two different judgments. A judge by, I think, Judge Mbongo, and another one that came from Judge Kumalo. It was on both sides. Kumalo favored us and Mbongo favored them. So we are sitting in that space. So there's no truth to the fact that we are not paying what we should be paying. There is no person or any entity like Discovery that is entitled to claim from the Social Benefit Fund.
Okay, let's put this another way.
Yeah.
If I break my leg in an accident, right, I have a claim against the Road Accident Fund.
Yes, you do.
Okay. But I also, if I belong to Discovery, would make a claim to Discovery because it's quicker, because my leg is broken, it needs to be fixed now, because I want to go to a private hospital. Discovery pays for my broken leg, right?
Because Discovery is forced by the Medical Schemes Act to pay for that.
Yes. Yeah. But you are also forced to pay for my broken leg because I'm the victim of an accident. Isn't that true?
If you did not have someone who is obligated. By the way, medical schemes are social benefit schemes. People don't know that. So you are claiming from a social benefit scheme. There is no social benefit scheme that is going to say to you, come and claim again. Which is why they are saying their members cannot claim from us. But they want to force the members to claim from us so they can take the money back to them. So Section 19... D of the RAF Act simply says that you cannot enter into a contract like that. That says once you get the money, you must pay to a third party, if that third party is not a lawyer. So they go and hire a lawyer to get around the scheme. So we are saying that it's wrong.
Okay, but if a South African, if any person is involved in an accident and breaks their leg, it doesn't matter it shouldn't matter if they're a member of a medical aid or not. They should get paid out by the Road Accident Fund. Right?
It should.
Why?
You are a social benefit scheme. Me and you, for instance, have got retirement annuities. When we get to 60 or 65, whichever time we retire, do we go to SASSA and say, give us the money? Simply because we have reached the age. It depends on your needs. And you must have had a loss or a damage. There's no loss there. It has been paid by medical aid, which is another social benefit scheme.
But that's not the way the Road Accident Fund interpreted for many years. It would pay out victims of car accidents who already had their treatment from the medical aid.
Talk to my predecessors and ask them why they were doing it. I'm saying to you, I'm doing it in terms of the law. So if my predecessors were doing something wrong, am I not allowed to correct it? I'm correcting it. The very same thing that you are talking about where you're saying 75% decrease in legal fees is what my predecessors were doing. So it's wrong to think that because it has been done like that, it must perpetuate a wrong. We can't perpetuate a wrong.
Okay. So the thing is that everybody who buys petrol contributes to the Road Accident Fund, right?
Absolutely.
Okay. So if someone pays into the Road Accident Fund and they're the victim of an accident, the argument would go they should get something out, whether they belong to a medical scheme or not.
No, but Stephen, let's get this right, because you always get it wrong. You are very wrong, my brother. Let me explain this.
I'm called wrong often, not very wrong.
In this case, you are very wrong, and I'll tell you why. When I am Collins Letsoalo, I'm driving a car. I hit Stephen, God forbid, with a car. I'm the one that Steve must get money from. Me. Okay? Instead of that, the Road Accident Fund steps into my shoes. When you try to sue me, you are suing the Road Accident Fund. So the actual person that pays is the driver, not the victim. The victim does not pay anything for them to be able to get that. That's why it's a social benefit scheme. So it is not the case that the person that pays the 2 rand 18 cents is the victim. It is not. It is the perpetrator. There must be wrongdoing. For that wrongdoing, you must be able to prove loss or damage. Under that case, then the road accident fund will step into the shoes of the wrongdoer and pay you as thief. So it's not true that the person that is the victim is the one that pays the 218 cents.
Okay, so when Discovery say you're guilty of contempt of court, they've completely got it wrong.
Well, I'm still here, Steve. They've been trying to get me to prison, and they have failed. Why? Because there's no such a thing. I've not contempted anything.
Okay, there's a similar story in the news today, interestingly, about someone else, Floyd Brink. I'm sure you've seen. Okay, let's move to the accounting standards case, okay, which, I know people have been talking about this week. You say that you're a social benefit fund. You changed the accounting standard that you were using. As a consequence of changing the accounting standard that you were using, the road accident fund went from having liabilities of, I think it was 330 billion rand, to having liabilities of around 30 billion rand. Why did you decide to change the accounting standard?
Simply because there is a thing called, at the time of the accident, for instance, the argument of the previous accounting treatment was that once I get injured, then it's a liability to the fund. If I drive today and I hit a tree on my own, the road accident fund is not liable for me. Okay? If, for instance, I'm driving a car and there are people in it and there is a tire burst, okay? There's no wrongdoing from me. So there's no way the road accident fund would pay. So there are instances where there are exclusions. A lot of them, by the way, in terms of Section 18, Section 19, Section 23, Section 24, all those things that you must do for you to be able to, for it to be a liability. So in accounting, we don't attribute liability like that. So there is an accounting way of getting a liability, and we are saying a point at which that happens. Earlier on, people were saying once the accident happens, and we are saying it's not there. It's once you have done and the merits have been assessed. That's the difference. Okay. So this is a contingent liability per se. It's not even a liability. Yeah. So we were not even allowed to do a contingent. People were calling it a liability, and we are still saying it's wrong.
Okay. So did you go to the accounting board and say we want, because they're the ones who actually have authority over public entities, so government entities. The accounting board of South Africa decides what accounting standard they use. And they're the ones that you were in court with them, you lost the case against them, they won. And here's the question, okay? Isn't it true that they get to decide which standard you use, not you?
No, Steve. We are in court with the Auditor General.
Yes,
we are not
they've
in court
refused
with
to sign off the accounts because they say the auditing...
No, they signed the accounts. That's the issue. They signed the accounts. They then said this is a disclaimer. A disclaimer, Steve, happens when you have not given information for the auditor to get to a conclusion.
Sure.
Okay? We have given them all the information. That's our argument. Our argument is that at best, this must be a qualification. It can't be a disclaimer because we gave you all the information. And by the way, the very same accounting standard board on the 23rd of August 2021 agreed with us on how we must treat this thing that IPSAS 42 can apply. It's there, it's in a letter. It's not something that we are talking about. It's there.
Then why did the court rule in the favor of the Auditor General?
No, but that's the part where we are saying that the court has misdirected themselves. Firstly, the court says we are not a social benefit scheme. Directive 1, that is issued by the FSB long ago, says that we are fundamentally a social benefit fund. So the court can't appropriate itself the right to classify any entity. We are classified already. So we are a social benefit fund, and they are getting in wrong by saying that we are not a social benefit fund.
Okay, so you're appealing this.
Absolutely.
You're obviously very confident. It'll probably go to the Constitutional Court.
If it does, yes.
Okay. Yeah. If you're wrong, I mean, the consequences would be quite intense. I mean, would you stay at the Road Accident Fund if it turned out you were wrong? Because the liabilities would go from 330 billion to 50 billion.
Let me tell you the consequences. The consequences are that we are just going to change the accounting treatment and then treat it like that. The biggest consequence is that when you sit here, all the social benefit schemes are accounting that way. Imagine if we have now reduced it by 300 billion. You go to UIF, you go to the compensation fund. All those liabilities that are included in the wrong treatment that we are actually pushed towards. The state cannot overstate the liability like that. It's wrong. And we are saying that it's wrong. We are saying that let's go back to what we are, which is a social benefit scheme, and account in it like a social benefit scheme. By the way, what is interesting is that people don't know that South Africa never had a social benefit scheme accounting standard, which the ASB itself was supposed to issue out in 2008. We are sitting here, it's 2024. We don't have it. But anyway, we are comfortable because they have now brought in a draft, which we are commenting on. But that draft is very important. You must go and check it if it agrees with us.
Okay. Well, let's see. I mean, as you say, we'll wait to see what the courts say, and I imagine it'll go a little while. Earlier this week on Newzroom Afrika, I don't know if you saw it, but I thought it would be important to give you a chance to respond to it. Nkuleko Khlengwa, the chair of the Standing Committee on Public Accounts. I know you and he are friends. You get on. I don't know if you have a beer after your meetings. He's been very critical of you.
Yeah.
Okay. And he made the point that during the Scopa visit to your offices last year, they found piles of documents in your parking lot. Are those documents still there?
Which documents are they?
He was the one who said that there were piles of documents in your parking lot.
Well, he's been saying that for a long time. Let me explain this. Steve, I can walk around here. I can walk around all government departments. I'm going to find paper. If he says he found them distributed all over, no, they were in boxes. These documents, they were in boxes. And these documents were serialized and everything else. We knew where they are. Let me explain this. If the Auditor General comes and asks for Steve Grotes's file and they can't find it, they are going to come with that disclaimer to say we can't find information we are looking for. We have never had that problem because those things are there. Section 24 of the RAF Act says that people must bring physical documents, and it also says they can post them using registered mail. Of course, the system works on paper. Paper goes into files, files goes into boxes, Steve. So there's nothing wrong with that, by the way.
Part of his point was that they were not being digitized, and shouldn't they be digitized?
Digitized in what way? I'm saying to you, it says we must get them physical. That's what the law says. So what do you want me to do with them once they get there? Okay. Digitized in what way? Because they are pieces of paper. No, you can go anywhere. Z83s of all these government departments, do you think they're all digitized? Because it is the law that
there's a Home Affairs plan to do that right now.
No, but that's what they're doing, and that's what we are doing as well. We have got a project that is sitting digitization, but you don't expect to come in now and find digitized documented draft, because they can never be. Because we are receiving thousands and thousands of these claims every day, and all of them come physical, and we must file them. And we file them, and we put them in boxes, and there's nothing wrong with that.
Okay. There's one other issue that I think might be important to bring up. Maybe we can agree on this one, which is, if you look at the way that the Road Accident Fund is funded at the moment, and the Road Accident Fund's been in the news for many years for lots of different reasons, and it's actually a very complex thing that government tries to do with the funds. Not an easy thing at all. Is that it is funded through a levy on petrol, and then that goes to the victims of car accidents. You've explained how that works. At the moment, do you think it's sustainable over the longer term to continue doing it in this way? Or do you think we need to make a change, maybe to how it's funded, maybe look at compensating victims of car accidents in another way? Do you think the current model, let me give it to you in a sort of broad question, is the current model of funding for the Road Accident Fund the right way, or are there better ways? Well,
we've been trying to look for better ways. If someone has got a better way, they must tell us, because the Road Accident Fund starts in 1942. It actually opens doors in 1946 as the third-party insurance. In 1950, it has already collapsed. There is a commission. It has got 9 commissions that have gone through it. And the only way that you can actually get money that is aligned to the number of travel, the kilometers you travel, must be a petrol. And that's an easy way, because once you pay, then we get the money. If anyone has got a better way of actually funding it, we'll be happy to do so. Is it sustainable going forward? Of course not, because now we are going to electric cars. It might mean that we must change that model. We are looking for a better way to fund it. But at this point, this is the best way of actually funding it.
Collins Letsoalo, thanks very much. When we get all these verdicts from these court cases, can we chat again?
Absolutely.
Collins Letsoalo, thank you. The CEO of the Road Accident Fund.